Yeah.
Right.
Okay, we are live. It is Friday, April 9th, Senate Government Operations. And what we're going to do today, committee, is a couple things. We're going to hear I never can remember the act number. I can remember it was S-124, but I don't remember the act number. We requested a bunch of reports to come back. Some were official reports and some were just to report to us on different aspects. And two of those were, there was usually a lead agency or organization that would lead the discussion, and two of them were assigned to the AG's office. And those two were because Julio had talked with us before about different forms of citizen oversight committees and citizen review committees, and we felt we needed to be very careful instead of designing any kind of a model to look at what the different types are, because different types might fit better into different types of communities. A small community without a police force might have a very different one than Burlington, that has is a city with its own police force. So Julio had talked to us a little bit about some of those before, and so we just asked him to come back, having done some research, and to look at it. And then this is something that hopefully we can get out to the communities so that they can, and I think the LEAB was involved in different people. So we're going to hear about that progress. And then we're going to, the other thing that was assigned to, as the AG, as the lead, was whether or not there should be a central reporting point for allegations of misconduct by law enforcement officers. And if so, where that should live. Should it be in the AG's office? Should it be with the council? Should it be with the academy? So anyway, and then how much of that should be public and when should it be public and all that information. So those are the two that we're going to hopefully hear a little bit more about today. And then at, I believe it's 2:00, we're going to do a walkthrough of the Code of Ethics and hopefully vote out H-135. So any questions, committee? All right. So Julio, thank you for joining us.
Good to see you. Good afternoon.
And so do you want to just take it away?
Okay, thank you. So for the record, I'm Julio Thompson. I'm an Assistant Attorney General, Director of the Civil Rights Unit. Madam Chair, there are a few members of the committee who I don't think have heard me testify before. Do you want a little bit of background about my work in policing oversight, or just proceed to
Sure. Yeah, no, that would be great. And do you know everybody here? I figured you probably did.
Yes, I've met them before in different contexts, but several members here I haven't talked on the subject of policing before at all.
Okay, great. Well, sure. So a little background of information about your background would be helpful to the committee, I believe.
Okay. So I moved to Vermont in 2004 from Los Angeles. After graduating from law school, I practiced as a lawyer in Los Angeles doing employment, labor, and civil rights work. My first work in the area of police reform began in November of 1991, when there was a series of shootings of African American and Latino community members by the LA County Sheriff's Department, which at the time was the fourth largest law enforcement agency in the country. It's as large as the LAPD in terms of patrol and policing functions, and it also runs the LA County Jail, which is the largest jail in the country, in the West, really, with about 23,000 beds. Wow. It's a big organization. And I was asked to be part of a 6-month study of the LA County Sheriff's Department top to bottom to look at issues of use of force, citizens' complaints, accountability and the like. At the time, this was a department that was facing allegations of severe beatings, of chained prisoners, of white supremacist gangs within the agency itself. The outcome in July of 1992, which was 2 months after the LA riots following the initial acquittals of Rodney King, there was a report with about 275 odd recommendations for reform. The LA County Board of Supervisors, which funds the Sheriff's Department, decided to create basically the country's first police monitor. And we'll talk about monitoring models for oversight. But they created an office of monitor. At the time, they called it the Office of Special Counsel because it was staffed by attorneys. That was responsible for ensuring implementation of those reforms. So if the sheriff said, okay, we will change X or Y, it was the monitor's job to dig in and embed itself in the department and report back to the board on progress on those reforms. At the same time, the duty of the monitor was to research best practices from around the country and also overseas, in Ireland and the UK in particular, to identify better ways of encountering the community that provided less risk for officers and the public, and to work with the department to introduce them, to those best practices. So I served as a deputy monitor in that setup from 1993 to 2004. After I accepted a job at the state of Vermont, I ended up resigning and then traveling across the country. When I was in that position as a deputy monitor, the areas I focused on was citizens' complaints and officer accountability, use of force tactics, de-escalation, crisis intervention, the canine unit and SWAT units, as well as incarceration, the mentally ill. Part of that job wasn't just doing document review. A monitor's office really, to be effective, has to be enmeshed in the department. So I participated in academy and also continuing trainings, including scenario trainings as a role player as the officer, the hostage, the bystander, or the perpetrator. I embedded with the canine unit and rode with them to calls. I rode with the gang enforcement team and all of the specialized units so that I could see from a day-to-day operational standpoint how the department really works. A monitoring entity that is confined merely to paper review is sort of like surveying the ocean from the deck of a cruise ship. So part of the monitoring model, though it sounds maybe more like an auditor where a lot of it is done by paper, it involves a lot of time that's spent in the department, but also in the community. So we spent a lot of time with all of the community organizations, business leaders, victim advocates, and the like. Following that work, or the start of that work, which started to yield results in Los Angeles, other cities started to notice the work of that monitor's office. So in 1996, the city of Detroit hired the monitor and me to do a study of their use of force and accountability systems following the murder of a Detroiter named Malice Green by 2 Detroit police officers who were convicted of the murder. It was a beating death and quite grisly. We also were asked to then go to different parts of the country and look at their existing or proposed remedies for policing practices or civilian oversight. So that included cities like Philadelphia, Burbank, Oakland, Phoenix, Portland, Oregon, and Denver. In 1999, I'll just try to shorten this up. I don't want to run too long. In 1999, the U.S. Department of Justice asked me to train its lawyers on how to review police shootings from the outsider perspective. And then that led to work that I've been doing off and on as an expert for DOJ on a number of cities, including Washington, D.C., Seattle, Baltimore, Newark, Maricopa County, Arizona, and most recently, Springfield, Massachusetts. I worked on an investigation that was completed last year. Within the state of Vermont, my role is principally in the civil rights unit has been more in the area of hate crimes. I do training with at the police academy on hate crimes. So a lot of the expertise, if you can call it that, I just call it experience and learning, comes from a lot of work that I've done in other parts of the state. I have not participated as a monitor or an oversight member for any entity in the state. I have provided technical assistance from time to time to the state police, as well as some municipalities, on ideas that they are either on issues of investigations or models that communities are thinking about for their own version of oversight. So that's my background. I've never served on a review board as such. My personal involvement has either to serve as a monitor or deputy monitor myself, or be tasked to audit review boards and police departments coming in from the outside to find out what works and what doesn't, and to propose fixes to make sure that it's meeting what the community wants them to meet. So I'll stop there if there's any questions about that.
Anybody have any questions about, Senator Clarkson?
Well, after becoming such an expert on all these things, Julio, all over the country, the obvious question is, why Vermont? But we can have that offline at another point, but I'd love to hear that story.
Yeah, I mean, with the great indulgence from the two attorneys general that I've served with, they've allowed me to continue to do this work on my off hours. So my vacation time for many years has been spent on these other entities, and I'm still engaged on some of those projects. So it's not something I've surrendered. I mean, I'm still working on those issues with, right now, most of it involves either a federal consent decree monitor. I work for the consent decree monitor for Newark, New Jersey. I'm on the monitoring team. So right. That's a court-appointed position. And then I'm also serving as an expert for DOJ on Baltimore and Maricopa County. Wow. So there are a few things I think I've learned a lot more than I've taught or shared during the period of time. And there are a few things that along the way, at least for members who haven't heard testimony on the subject before, that are just lessons that were learned over time. And there are a few kind of key principles to keep in mind. One, the history of civilian oversight in the United States is not a very good history. There have been different models of civilian review entities for going on to 50 years in the United States. They all follow, or nearly all of them follow, a familiar birth story, which is that there is some critical flashpoint in a community, or sometimes nationally, as happened initially with Rodney King, and we've seen it several times since then, including what's going on in Minneapolis right now. And then and usually at the municipal level, there's a rush to create some sort of entity with vaguely defined powers, usually little funding, almost no training. And then they are tasked to meet once a month and do something, whether that's reviewing completed investigations or taking civilian complaints and the like. The other story of civilian oversight is that there's constant evolution of these entities. So the cycle of these, and I've provided, I think, the committee a white paper from the National Association for Civilian Oversight of Law Enforcement that talks about the history of the different models, is that many of them go through a cycle where time passes, the entity is forgotten in the public eye, and then additional critical incidents arise, and then all eyes are back on that entity, which is found to have been ineffectual, and then there's another reform. History teaches us, I think, who work in this area, and people in the communities that have worked in the area of police reform and civilian oversight and partnering, is that the quick solution doesn't usually work. And that's especially the case where it is a sort of top-down, a proposal where it comes from someone who already works in a city or county government. They come up with an idea, or they take an idea from another similarly sized city, and then they propose it, and then there's a limited period of public comment from the members of the community who are supposed to participate in this model and be served by it. The more successful efforts have really worked in the opposite way. They are born from ideas that are provided by the community first, that those ideas that principles are staked out by the community rather than the government. And then it is the government's role to try to match town and government operations to meet those needs. And part of those discussions necessarily include law enforcement, since they are going to be the ones who will be governed by and interacting with whatever the civilian oversight entity is. So they can't be excluded from the conversation, but they are, they are a co-producer of public safety. The community is the other co-producer. And so the more successful model or approach to developing a model builds up from the community. And so in connection with the work that we've done here so far in the AG's office, and we're not done, pursuant to Act 166, Chair White,
Thank you.
Section 16, we were tasked with soliciting input from different community groups, and municipalities to talk about what they want, or what they think they can afford, what they think they're missing in terms of police accountability. And as you can expect, if you read the newspapers, in the last year and a half, even before the murder of George Floyd last May, they were already working at revising or attacking the issue of accountability to make sure that the police are serving the agenda, or meeting the agenda that the community really sets. And so we've seen in the last year efforts, obviously, in Burlington and in Brattleboro. We've seen it in smaller towns like Bennington or Vergennes, where communities are themselves doing the research and trying to identify what fits their organization. And it's important, as the chair noted at the outset, is that the size of police departments in Vermont varies widely. There are departments that have 2 officers, and many departments that have fewer than a dozen officers. And so the capacity for a town to build or to invest in some larger structure to govern a dozen officers or fewer isn't really, or historically hasn't been viewed as an economical way to approach it. And so the default position in Vermont has been that it is the town managers usually, or the town select board, that are the ones who are expected to cast an eye on, say, an investigation of a complaint or a critical force incident. And in many cases, they don't have any training or support in the area of law enforcement. So they're at a serious disadvantage when it comes to evaluating, as an honest, neutral broker, what the circumstances are. And also they're at a disadvantage to know what alternatives to conflict, or encounters in conflict situation that are available to the department. It may be that the department or an officer follows a policy, but the problem may be with the policy itself. And historically, Vermont, it's no different than many other states. Towns and cities have individuals that just don't have that sort of background. And so that's kind of the problem statement that exists right now. So I could stop right there before I start talking about the individual models, if there are questions, because I don't want to get ahead of anybody or myself here.
Does anybody have any questions right now? I would just, in thinking about whether we call it citizen oversight or review or whatever we end up calling it, is what really is the function of the committee? Is it just to review allegations of misconduct? Is it to, I mean, I think that it's important for people to understand what the breadth of the responsibility is and how that gets defined.
That's a great question. There really is no limit on what a community's participation in law enforcement is. And that's the way historically I viewed it. It's not merely oversight in policing, but participation in public safety. There are many models. Sometimes it's in a police commission model. Sometimes it's in the monitor model, where the community has direct input on the policies themselves, that they identify existing policies, do research on what are national best practices, maybe consult or engage experts, but also define for themselves what sort of police responses they want for certain types of calls. And so, for example, in Brattleboro in January, it released a large report. It was a major undertaking for Brattleboro, where a very useful section of the report, we don't have time today to go over it in any detail, but the community's review of their own policies identified what they viewed as systemic biases towards confrontation, towards an aggressive model of policing, towards, that basically captured a mindset that, according to the authors of the report, didn't really align with what the community was expecting its police to do. There are many models of, or many cities that have civilian entities that are responsible for providing that input and approving policies that serve the community. So it's not just complaints, it's the very policies themselves.
Senator Clarkson.
Thank you, Julio. I think our chair has also touched on this. I think you're right. I think it seems to be much more effective if it's community engagement and it's not just responding to complaints or responding to bad, awful things happening. It's really proactively addressing what is community's engagement with its public safety. What does it want? What does it need? And how do they envision it? How does it help further the vision and goals of the community?
Yeah, I mean, for example, when I worked on the Seattle consent decree, so in that one I worked for the court-appointed monitor. So the consent decree is overseen by a federal judge, and then in that case, he appointed a team of individuals with experience in police reform to oversee and monitor the Seattle Police Department's changes in how it was going to comply with constitutional policing and meet the community standards. A big issue in Seattle when we started, I think it started that in late 2013, was there were certain areas in Seattle, certain parks or squares that were frequented by individuals, or maybe were the homes of individuals who really were not supported by any of the existing systems for mental health or housing. And a study which we oversaw to identify the amount of 911 calls or police calls for service for these areas where there were only a few dozen individuals that were accounting for many hundreds of calls and many thousand, by different officers all the time. And so the community, they have a community council there that, that offers recommendations for policing. And they were very supportive of the creation of a unit of officers with a background in mental health and social work to be assigned to those areas, so that they knew after a period of time all of the people who occupied those areas, and so those officers knew the individuals, the residents, the community members, and vice versa. And in most of the cases where there was some public disturbance or nuisance, it related to medication or housing issues, and their job wasn't really to show up with the handcuffs, but to make the calls and cut through some of the red tape in the city to get those individuals back in treatment, in a safe place at night, where they could avoid risk from other members of the community. That was dictated by the community. It was saying, why should we have these same couple dozen individuals encounter over the period of a year, maybe 20 or 30 patrol officers who don't know anything about them? They just show up and it's just another guy who lives in the park, rather than investing the time to have the department's employees zero in on these people, almost become de facto caseworkers, or work with their existing caseworkers so they could meet those needs and get some of them, as many as they could, off the streets and certainly in treatment where they needed both medical attention and really rehabilitative services. So that was an example of a setting that came directly from the community. And the department, which was under a consent decree and had a new chief who was very effective, Kathleen O'Toole, former chief of the Boston Police Department, they were very, very receptive for that. It was a win-win for the department, because what they found is once they made that small investment, then the volume of the 911 calls started to decrease. And the use of force in where individuals would have to be removed from a scene because they presented a risk to themselves or others, the uses of force were cut by roughly 75%. It was really remarkable, because the people arriving at the scene didn't come with an arrest or use of force mindset. They came there more as with a guardian or a caregiver rather than a warrior mindset. And so when they arrive at the scene, it was all about helping that individual rather than forcefully removing that individual or commanding them to leave and then using force if they resisted. So that's just one example, and it's been utilized in other cities. That's just one I have some experience in, seeing how that program developed. So agenda setting and policy is one of those areas, and related to that is community input into training, officer training, to not merely to comment on officer behavior after it happens, but to make the investment up front to see whether they are training their officers to engage in confrontation. And so, that if you have having civilian or community input means that they should be welcome to review. It shouldn't be secretive in most cases. I mean, some SWAT-like tactics you don't want publicly disclosed for safety reasons, but in general, for the public or the community to be able to see firsthand what the training is, participate in it, and watch officers run through it, and then see, whether their approach matches up with what the community's expectations are. So, when I started in doing this, ages ago, one of the more frustrating areas of of police encounters would be an officer's encounter with someone usually in crisis who had an edged weapon. So they had a knife or they had a broken bottle, they had an umbrella, they had some sharpened object that presented, was a deadly weapon, and no question, it was something that if they were able to strike out at somebody could cause serious injury. Most of the training in most of the United States, the paradigm was all about appropriate distance and getting the firearm out, getting it in the low ready position, because the teaching at the time was to demonstrate how quickly someone could close the gap. There was a famous 21-foot rule that came out of a trainer from Salt Lake City, Utah, where they were trying to demonstrate for officer safety purposes that someone could close the 21-foot gap before an officer could unholster, point, and fire to defend themselves. There was very little focus on things like backing up or moving so that there was an obstacle like a car or a table between the person with the weapon and the officer. It was really only, there's been very slow progress, but progress on getting officers to focus on de-escalation. That every minute you spend talking to someone with a weapon and they're talking to you and they're not using the weapon is a victory for that officer. To allow other officers to arrive, if there's family members that need to be, at a distance, at a safe distance, that can help in the de-escalation, then they could do that. But you would see the results, and when I did monitoring, you could see the results on the street. The officers were just following what they'd been trained. And in a high stress situation, any professional, it's not just police officers, it's EMTs, it's airplane pilots, it's air traffic controllers. When they're in a high stress situation, they don't have much time to think. They will resort to their training. It is what's most available to them. And so participation in training, if you have the right training, and the training in an edged weapon encounter is time, distance, and talk, then that's what they will start to fall back on, rather than tactical position, unholster, low ready position. Because once the gun is out, the officer's options are very limited. Mm. Now the gun it's an asset for the officer, but it's also a liability because it's a deadly weapon that the officer might lose in the fight. So once it's out of the holster, the officer has narrowed a lot of their options. Certainly de-escalation is almost certainly off the page, because almost no one reacts positively if they're in crisis to seeing a drawn gun. And if the person closes with the officer, they would have to reholster and go downward to maybe use pepper spray or just to put their hands out to create distance. So resorting to that gun sort of traps the officer into a very narrow range of choices. And if that's the officer's training, then you'll get those predictable results. And so exposing it and, transparency on training, to get a fresh eye from the outside, to see how, if they do scenarios, what do the scenarios look like? Do the scenarios always have the bad guy? That's always a male. That's always a person of color, those sort of examples. It trains officers to disregard risks that might be presented to them by white females, for example, where their training examples are just, if there's a group and there are shots fired, I'm going to focus on the male as a potential threat. And that's dangerous, not only to those individuals, but that's dangerous to the officer, because they may be zeroing in on the wrong person. So that focus on the outside look on training can be very, very valuable, and starts to slow down the pace, if not eliminate the sorts of bad outcomes on the street. So I'll stop there.
I noticed that I think Senator Rahm had a question.
Yeah, Julio, before we go on to the models, I hear you defining the problem statement, but kind of taking the same statement you just made and extrapolating it out, when there's a crisis in a community around their level of trust of the police, that's often when the police stop wanting to listen and hear what that crisis of trust is coming from the community. So I'm really curious how you and the Attorney General's office are working with police departments around the state to be at the table in equal relationship with the communities that they serve. Because I hear a lot of police officers, frankly, saying, well, we want to hear the community, but, we want to sit down at the table with them, and they still want to be at the head of the table. I don't think they really know what it looks like to truly be in equitable relationship with the communities they serve and have civilian oversight and have that conversation. So I feel a lot of defensiveness from law enforcement agencies, and that's not a good place to start these conversations. It doesn't build trust. So how are you helping them define the problem statement? Because we can't get to all these models until they are willing to sit down with the community and see that they have a problem with trust.
And I'm going to follow up with that, if I might. I believe that one of the weaknesses that was pointed out, and I may be wrong here, but I'm pretty sure I'm right, in the Brattleboro study that was done, was that law enforcement was not allowed at the table at all. There was no communication there. So that was the other side of what Keisha's alluding to here, is that you need to have both, and they need to be equal partners.
There's actually, so I could talk to some examples. I mean, you both have defined the issue perfectly. There's inevitably resistance and fear when there's any kind of reform of an organization. And that's true of law enforcement as well. I could talk about some historically or examples that I've seen where, or how those fears manifest themselves, and to note success stories or failures. On the issue of participation, for example, in Seattle and in a different committee, in the judiciary committees, I've been testifying with others about the use of force policies and things like that. A lot of folks have been looking at use of force policies that really have spread out from Seattle. Seattle is viewed as having one of the more robust use of force policies in the country. I'm very familiar with that because I was working on that with the police department and the community and the unions. In Seattle, I think the agency and the city was very focused on participating with the community and very focused on dealing with the monitor, because they had to, frankly, they're under a court order. But I think the reports that came out was that there wasn't that much input with the officers union about what the changes were going to be. And as a consequence, or certainly related to that, shortly after the policy was issued, I think it was 110 officers filed a lawsuit to enjoin the policy, and to make arguments in court about why this policy was inappropriate and put officers at risk. The lawsuit did not have merit on the law, and it was ultimately dismissed. But it was an example of the sort of failure, a process foul, if you will, that was committed during the development process, where not everybody felt like they had an equal voice. A lot of these officers sued on their own just because they themselves felt threatened and thought that options that they would use to save their lives if they were in high-risk situations were being removed. And that was very motivating to them. So you're right that everyone has to be at the table. One of the more successful use of force policies in the last 2 years that's been developed came out of Camden County, New Jersey, when Scott Thompson was the head of that department. And their use of force policy, which is viewed as, again, one of the standout policies in the country, was a project between New York University's policing project, the local ACLU and NAACP chapters, and the Fraternal Order of Police. That they were all, there was community involvement as well, but everyone worked together. So when the policy was at its final stage to be presented to the county government, the rank and file and the officer unions had provided their input, as had, again, other community stakeholders. So you're absolutely right that a successful outcome requires all voices there.
So how do you get to that point? How do you convince the law enforcement officers that the community needs to have an equal voice and they need to be there? And how do you convince the community that the law enforcement needs to be there at the table also? And how do you choose, I guess, which community members you're talking with and which police officers you're talking with? Because is it leadership in the police department that, I don't know if, I think we're getting into a little into more detail here. And what I'm going to suggest is that we continue this conversation for maybe 15 more minutes.
Okay. Because
I believe we have the ethics walkthrough at 2. Am I right about that? Gail, is that right?
2:30.
Oh, 2:30. Okay. So we have until 2:30. So let's, but I think we're going to continue this conversation again at another time also. Okay. So thank you, Senator Collmore. I was getting a little nervous here, but okay. Thanks.
So there are a couple of issues that I identified. We're not in a position really to recommend a given model yet. And part of that is that the community input process for us is not done. It's not close to being done. A key ingredient for a successful change is that you have to spend the time. It's a slow moving process because you need to provide multiple opportunities for the community. It's harder to get the community's input because they're so diverse. It's not that hard to get a city attorney and a police chief in a room, but it's harder to get members of the community, particularly those who are afraid of their police departments, in the room or in a group setting. So it's more time consuming, but you have to invest that time, not only at the beginning, but as policies or training are being drafted, you have to provide multiple opportunities for people to take a look at that. So that's part of it. And that contact, if it's a respectful interaction, I find helps the relationship. Time spent in the room when people realize that the people who are on, quote, the opposite side, don't have a pitchfork and tail, that kind of thing. That you're talking with individuals. The personal interaction and regular interaction is really important. Yes.
Senator Collmore.
Thank you, Madam Chair. So one of the things that this committee and the legislature in general seems to struggle with, and I don't know that there's a right answer to this, is to get a sweet spot in terms of the number of people that you involve in this type of situation. You reach a point where if you get to 15, 16, 20, there's too many people to actually be able to get a lot of stuff done. But if you don't involve enough, you risk leaving an important voice out of the process too. Right. What have you discovered, Julio, in terms of sort of hitting that sweet spot in terms of the number of people involved?
Yeah, there's really, in terms of the community involvement and all the projects I've worked on where there are changes of policies, for example, there'll be a draft policy that is posted for public comment for a period of months. There might be public meetings to go through that policy. It's almost like rulemaking, a proposed rule and a comment period. In terms of organizational interactions, the community organizations are really vital because there will be people there who might have training or experience in the area. So they come to the table with knowledge, or they've come with models that they've gotten from, sister organizations. But those individuals are also going back to their constituency, and they need to have the opportunity to be there without you in the room. So if, you know, like in one city, I won't name names, but we might be talking about a policy with somebody who represents a local NAACP chapter, and then they're going to go back and talk to a whole bunch of people without you in the room so that they can have that candid discussion without, you know, wondering what, you know, you might say or think about them, even as an outsider where, you know, I might be somebody from another state. So just to give them that ability. So using those organizations as conduits, and also giving them advance notice of what you're going to talk about, so that before you, let's say you would meet with NAACP, for example, if there was a draft or an outline, you'd send it to them in advance and give them time to go talk with the community and get their input again on their own, fully candid without you, so that when they met you, they were ready to talk. They weren't just kind of reacting in the moment and not having an opportunity to get that advanced feedback. And that's part of what slows it down a little bit. But you really do get very, very meaningful input that way. Places that don't follow that typically will have policies that will go out and that will generate unintended results for everybody, for the community and the department. And then they have to go back and change that policy or the training and involve more people. So it's better to get it right at the outset. And so like in some of the consent decrees I've worked on, people are involved in the proposal, the drafting, you know, like multiple red lines. There's public posting where you get written comments. And the people who are more involved in the drafting process from the community and the agency work on that. And then again, there's community meetings that are led by community members who will explain, let me tell you what this policy is going to be about, you know, say police dogs, like some city might have issues with officer use of canines for searches or high risk arrests, you know, where someone's in an attic in a burglary and they need a police dog to identify somebody, how to do that safely. And so they'll present what the policy is going to be. We're going to keep the dogs on leash. It's a find and bark policy rather than a find and bite policy, and explain it to them and then get that additional input. I've never seen the public input, you know, in the near final draft that didn't elicit really good ideas that everyone missed at the beginning. It's inevitable. So it can be time consuming, but it's really, really valuable. And it really does help people feel more ownership from the agency side, but also the community side in that policy. And what inevitably happens is that you have to then launch the policy and train on the policy, and then have a community commitment. You're going to come back in the next year to see what changes you need to make, because experience will generate situations where you think we didn't quite capture what we needed to do. We need to make tweaks or adjustments, and you just need to accept that. And for any good, let's say de-escalation or use of force policy and training, if you go on the web and look at the versions of the documents, you'll see it's like version 7 or version 9, because there will inevitably be situations that arise that people didn't think about and say, okay, you know, our model for handling something like a call where someone's in a position of self-harm in a residence, that it's not meeting what's actually happening in the community. And you just have to be open about that. Police leadership obviously is important, but so is community leadership. What's really vital, I just want to say this, just to get this in, because it was in the Brattleboro report. I was happy to see it. They quoted a passage from a study done by the Police Assessment Resource Center in Los Angeles, where I worked from 2002 to 2004. that emphasize the really critical need for the government, the governmental entity, to provide training support for any members of the community who are participating in the policy development or oversight. A principal concern, it's not just, it doesn't happen in policing. It happens with engineers. It happens in the airline industry. There's always a concern where professionals are subject to oversight by individuals they don't feel understand the profession. They don't understand, and this happens in medicine. It happens in law. It happens in teaching, where individuals want to make sure that those who are involved with evaluating performance or evaluating policy are themselves at least fairly well acquainted with how the occupation actually works. And a long-standing failure for a lot of civilian oversight entities is they say, okay, we're going to get 5 community members. They're going to represent these constituencies. And these individuals, it's good to get a broad selection. You have somebody who works in real estate, someone who's a basketball coach, someone who's a substance abuse counselor. And then they're kind of thrown in there, and they don't know what the rules are regarding searches after an arrest. They don't know whether an existing strip search policy meets the constitutional standard or not, or whether there are better practices out there that keep safety in mind, but also afford people more dignity. And so the Brattleboro report, I think, really zeroed in on an essential need. Whatever is the outcome here, is that there do need to be supports and resources for training opportunities so that board members are acquainted so that they can be effective. The part of the Brattleboro report found that where they've done studies of those reports that don't have the training, over time, the community oversight, so to speak, ends up agreeing with the department 90% or more of the time. Now, I can't say whether that's the right percentage, but what academic and other studies have shown is that the lack of knowledge works to the disadvantage of the community in terms of its effectiveness, but it also is an impediment to trust from law enforcement, because the rank and file may recognize that the people who are evaluating their work aren't familiar with the occupation, aren't familiar with the laws, the many regulations that apply to the profession. So it doesn't really help anyone if you don't provide those supports. And so I think looking down the road, again, we're quite a way, I think, away from offering our final views on this, but it's hard to imagine a situation where you would have an effective entity or entities of any form where they didn't have access and perhaps a mandate for training to make sure people are experienced enough so that they can become better issue spotters and better problem solvers because they're more familiar with the subject matter. On-the-job training historically has not been a very effective way of increasing the quality of community participation and oversight. So I'll stop there if there's a question about that.
Senator Rahm.
Well, actually, Julio, when you were talking, I was thinking about the year that I was arrested as a teenager by the LAPD for absolutely nothing, and it was 2003. So I wish I could say that I think the LAPD has improved, but the on-the-ground experience for Black and brown people would unfortunately tell me otherwise. And that's kind of what I wanted to ask about. It's gravely harmful for people of color to have to come out and say, this is not okay, and I am not okay, and the police are not doing their jobs properly. We just saw that in Bennington again, with a couple coming forward, having been given tickets 12 times in 20-something days, feeling like they were being run out of town by a lot of decision makers. It extracts a lot of pain and resources from people of color to have to speak up and go on the record saying that they are being harmed by the police and to file those complaints. And then nothing happens with them half the time. So I'm really like, I appreciate everything you're saying, but I'm not hearing what the Attorney General's office is doing to improve the situation. And I really want to make it specific to what are we doing, not what can we do? What would be ideal? But we are having a problem in Vermont, and we need to know what the Attorney General is doing about it.
Well, it's a great question. Under Vermont law, including Act 166, we don't have any authority over law enforcement reform other than criminal prosecution. We have representation on the Criminal Justice Council. We have one seat on that council. We don't have the ability, like the Human Rights Commission does, to do a civil investigation of racial profiling and the like. So we've been tasked in this law to get input not only from law enforcement, but from a broad range of Vermonters in different organizations to hear about what they want in terms of increased accountability mechanisms. So that's our job under 166, is to get that information and offer some recommendations or ideas to the legislature. Along the way, we certainly interact with law enforcement and members of the council to identify instances or problems that they're trying to solve. But we don't have a legal charge to do that. That's not, I mean, I can't make a police chief anywhere sit down to talk with me or answer to me or produce files for my review. We don't have that. I mean, one of the things we'll be talking about later as this project develops are models of oversight that include that kind of authority. For example, you may be aware the House passed the George Floyd Justice and Policing Act. And one provision of that law allows state attorneys general to conduct pattern and practice investigations, very much like the DOJ does for police departments, where they investigate whether an agency is, kind of chronically, systemically discriminating against the community. Vermont doesn't give us that authority. Most states do not have that authority. Congress is proposing it in a bill right now that's before the Senate.
Senator Clarkson.
Thank you. So, Julio, given that you feel you need further time to make a recommendation on community engagement or community oversight model, whatever we're going to call it, I would hope it would have a more proactive name. When do you feel you have that in time for us to take action here or later this session, this summer? When do you think you'll actually have that work done enough to make a recommendation?
I would say my best projection is it's probably going to run into the summer. In part, and I'm very proud of this, but there's been a lot of work right now in communities in getting certain underserved communities vaccinated. And so there's been a lot of energy that's been devoted to that, which I think is terrific. But I think we still have a lot of work to do. There are lots of folks in towns we want to talk to. And that's going to be on, in smaller sessions, but also we anticipate having, a number of, I assume for most of them, they'll be Zoom-based town hall kind of meetings. And then also soliciting, written input from organizations. We're also talking, by the way, and I'm a real believer in this. If you're thinking about creating an organization that, or building up an organization that engages in oversight, go talk to the professionals who do that. So, for example, Monday, I'm talking to a lawyer who right now works for the Pennsylvania Attorney General, but she worked for years as an investigator in the Office of Police Complaints in Washington, D.C., and then the parallel office in New York City. And she's agreed, by the way, to talk to some of the Vermont cities and towns about her experience, so she can tell you, what were her frustrations as an investigator under a given system. I think that's really one of the best ways to do it. So we're getting that sort of input from people who are either experts or people who work in the field.
May I just follow up? Yep. Which is, if you haven't done one in Windsor County or East Side, I'd love to be in. I mean, if it was appropriate, I'd love to be invited to one of those.
Oh, of course.
What?
Of course. Yeah. I mean,
but I mean, have you Have any of the rest of my colleagues on this committee been invited to join one of those?
I don't think, the person who on this project I'm working with, Dave Scher, Assistant Attorney General David Scher, who I think you've met before on more than one occasion. So Dave has been more the one dealing like with a lot of the scheduling. So I'm not really, familiar with like what the latest details are. But what I've been saying when I have been talking to folks is that we're going to talk to you more than once. It's not enough to meet with somebody for a half an hour or give them 5 minutes in a town hall, because what happens is we go on to the next group, we get their ideas, and then we want to go back to the first folks and say, hey, yeah, this is an issue we overlooked. What do you think about that? So it's very involved, and there'll be multiple opportunities. Any of the events that we do with communities, everybody's going to be invited from that. I mean, we're going to try to, arrange speakers who are from that community, but it's going to be available to everyone. And there'll be multiple opportunities because we're never tired of hearing from people. I mean, it's really, really important. It is, there's a lot of research to be done about existing entities and that sort of stuff. And we've done a lot of that, but it's really hearing what the communities want, because they have very different views about what they want.
And before I go to you, Senator Clarkson, I think we need to be really careful about, and this just jumped out at me when Senator Clarkson, when you said, I hope we can have a more proactive name or something like that, you said. And I think that we need to acknowledge that what we have in Vermont is many, many different types of communities. So we have approximately 65 or 70 municipalities that actually have police departments. We have about 180 towns that don't have police departments. So what Dummerston does in terms of its public safety and how it's going to respond to public safety is going to be very, very different than Brattleboro. Brattleboro can have some kind of a community involvement, community oversight, whatever it is. Dummerston has nothing to oversee because they don't have a police department. They don't have, so I think we need to be very careful about thinking that whatever we come up with, some places may call it a citizen review committee. Some places may call it a public safety advisory committee. Or so I just wanted to point that out, that we need to be really careful that we're not thinking that there's going to be something here that's going to solve this. And then I think we need to also make sure that when we're having these conversations, and particularly around investigating disciplinary actions, that kind of thing, that we remember that we have a whole new criminal justice council that has a really, really active right now investigation subcommittee that is made up of mostly non-law enforcement people, some law enforcement people on there also. So we need to be really careful that we don't set up something that is going to conflict with that. They're working very hard, the community representatives on there, to make sure that they're setting up the right kind of investigative oversight of. And so I just think we need to, it's much more complicated than just having Brattleboro set up some kind of an oversight committee. So I just wanted to point that out.
Yeah, I couldn't agree more fully. But I think it goes back 2 years to our tour of the state and to our thinking broadly about how do communities envision public safety in their communities, whether they have a police department or not. I mean, they have a vision. I bet if you ask people in Dummerston, or if you ask people in Reading or Mount Holly, places that don't have police departments, but that I bet they have if there was a group of people that came together to talk about what's your vision for your public safety? How do you envision? I mean, I think it's a bigger, I wasn't wanting to be prescriptive at all. I actually think it goes to our questions from 2 years ago, which is what's a community's vision for its own public safety?
Yeah, I agree with you. And one of the things that we are going to hear is the inventory that we've asked the planning commissions to do on how many towns actually have public safety plans and what is constituted in those plans. So we will be hearing from them about that inventory. But I think that really, in my mind here, the important thing is to be getting the community, and I'm talking here about the broad community with representing all aspects of its community, and the public safety people to be able to come together and talk, and there might be different things in different communities growing out of that conversation. And in some, I just think that is the most crucial thing, is to get people to sit down together and begin to form that trust so that they really can talk about what are some of the issues here and how do we approach them, and how do we and not necessarily even the community group coming up with the policy, but here's what we expect. Here's how we would like to see things happen in our community. And from that grows the policy, not the policy. Anyway, I'll be quiet now. Senator Rahm?
Well, I mean, we should probably let Julio talk a little bit more. And in some of his sort of final thoughts, I was just wondering, I imagine with most models, as you said, some towns have money for this and some don't. And we've started this conversation in this committee, regardless of the source of funding. I think the state needs to help the communities who don't have the resources have these conversations in a way that people are able to participate, which costs money. I can't imagine one of these models is free and effective at the same time.
No, they're not. And historically, that's where state government has lent its hand. Most civilian oversight entities, when you're talking about oversight of non-state law enforcement, so cities and towns, or counties, their law enforcement, the state doesn't have that much of a hand. It typically has a hand, and Vermont already has some of that. Vermont has a Human Rights Commission. Anyone who alleges a discrimination by any government agency, state or local, can go to the Human Rights Commission, which has subpoena power, has the ability to take the department or agency to court, whether that's law enforcement or any other government. We also have law enforcement certification, where officers, their quote license to practice policing is subject to revocation or suspension. In the last year, where states have taken legislative action, that's one area, which is that they've increased the role or the powers or authority of the licensing entity to investigate or take actions on officers who are engaging in actions either of excessive force or discriminatory policing, so that there's not only a consequence within the agency, whether they're disciplined or not, but their ability to practice the profession, as it were, may be an issue in critical cases as well. I think another area that you're going to see, again, I can't see the future as like what we're ultimately going to say, but it's hard for me to imagine that, and we haven't seen anybody who's spoken in opposition to it, but where the state could really benefit is to provide the kind of training support or resources for people. We have a state policing academy. We don't have any sort of entity for training or and skills building for people who are already right now engaged in law enforcement oversight. They are sort of on their own in terms of training. There are organizations like NACOL, which I've mentioned, that do provide training. I've done some of those trainings at the national conferences, but it's not really enough. It's very episodic, and it's not tailored to, the city or town or the state. So that's one area I could see where there'll be more discussions about whether the state can provide those supports, so that someone who's looking at a use of force complaint in, Northwest Vermont is applying similar skills and procedures and checklists or things like that as someone who's in, the southern part of the state, that they have a common understanding of what. One of the challenges really for these, it's kind of a details thing, but I think it's a good illustration, is that when you have an entity that might be looking at the department or someone's investigation of a critical incident, everyone can read what's in the file. But you have to have some training or experience to know what's not in the file that should be in the file. You don't know what you don't know, or you don't know what's missing unless you have exposure to that. And so, I mentioned earlier that I did this training for DOJ way back, I think it was in '99, about reviewing police shootings. We did a case study of a police or shooting investigation that a lot of the lawyers in Civil Rights Division thought was pretty good, but there were big gaps in the investigation, things that were not in the investigation that one would expect to be in a deadly force investigation that weren't there. And many of the people in the room, because they weren't familiar with that sort of that project of reviewing a shooting case, they didn't know what was missing. So what they saw looked good, but the problems were what wasn't in the investigation, what wasn't investigated, what wasn't analyzed. And you can't really know that just by being a good reader. You have to have some experience or some training about what are the essential components of a good and fair investigation.
I think when we're talking about training here, it just dawned on me that I think we have to differentiate between what a Brattleboro or a Putney or a St. Albans oversight committee would have the ability to investigate and review, as opposed to the council, the investigate, because I'm not sure that I don't know if what we want is for the Brattleboro Advisory Committee, or whatever they end up calling themselves, to be investigating a deadly shooting, because they haven't had the training. And I don't know that we can provide that to 250 towns, but we can provide really extensive training to the people who are on the investigation committee at the council. And it seems to me that we're talking, mostly what we seem to be focusing on is investigations of police conduct by these, we keep going back to that, to investigations. But I think that they need to be far more than that. And maybe the investigations happen elsewhere than at the community level.
It's a very good point. And I didn't mean to suggest at all that we would want to train, a couple of, select board members on how to become deadly force experts. I didn't want to suggest that at all. I was just using it as an example of even people who are well-trained and, very careful analytically. If they don't have training, they will still miss things. Part of oversight models are not just investigating. That's the most expensive model, where you build a new investigative entity. There are other ones that review completed investigations. The monitor auditor model, they're not decision makers on individual cases. What they do is they look for systemic failures. Mm-hmm. They look for, so they might say, I'm going to look at, the last 10 use of force investigations you've done to see whether you are investigating those cases fairly or not, to identify problems. or suggest best practices, or learn lessons. If there's an agency that's doing something really great, to share that, with other county or neighboring towns. So that's part of the auditor model, as well. Like the commission model is one that's more involved in policy and may have some role in the say of discipline. These are all big issues, and not every community agrees about the role or the investment that they want to make. But for the ones that are going to invest in a particular type of model locally, for them to be able to go somewhere or have a resource in the state of Vermont is really, really helpful, because there are a lot of people out there who are online consultants who offer training that may not even fit Vermont's view of law enforcement. So it's very hard to zero in on quality. So, like I said, going back to what Senator Rahm said a while ago, I think that you're definitely going to see a need for supports by the states, because the localities just won't have those resources. And it also helps to have some sort of uniformity, to have people have a common basis for training and to cross-train. So I think that when you have communities where people who are participating in policing in one community know their counterparts for other communities, so that everybody knows what they're doing and they're learning from each other, because they will all encounter many of the same issues. They might be dealing with issues of race, poverty, mental illness, homelessness, as well as law enforcement's role, if any, in the schools. And so to have some common source of information, I think, is probably going to prove to be very helpful. But we don't know the details of that because we're still listening to folks. And we're happy to talk to any of you or anybody you recommend as much as possible. The emphasis here is that it's multiple conversations with a lot of people.
Right.
Any questions or comments?
No, go.
Okay.
Good luck as you continue.
Okay.
And if you do anything on this side, I'd love to be a fly on the wall.
Definitely, sure.
And Matt.
Okay. Anything else?
You're muted, Madam Chair.
Oh, I'm sorry. I was going to suggest that we take a 5-minute break.
Yippee!
That we come back and that we schedule Julio in maybe 2 weeks to just come back and give us an update again, and also talk about the issue of the central reporting point, yeah, and whether you've made any headway on that, yeah, on that issue. And sure. And maybe when you come in next time, we can have somebody from the council and maybe a couple people from the community members on the council to join us in the conversation.
That's a great idea. Sure.
Okay.
All right.
Thank you, Julio.
Thank you.
As always, very informative.
Thank you for your time. I appreciate the attention.
Thanks. Okay, here we are back. Committee, remind me of if there were issues with H135, because I'd like to do two things today. I'd like to get that off our table. I thought that I was not here the last time you looked at H135. That was when I was sick with my shot. So can somebody remind me if there were issues with 135, or Amron, do you
I don't know whether I'd say there were issues. There were two things we talked about, which was getting clear about the difference between a guidance and an advisory, which is something we're having an ongoing need to continue to clarify. But there was this question about whether to insert the word only in guidance, right? Amron, am I saying that right? I'm not sure what page it's on or whatever.
Amron, can you tell us where that is?
Yes, I can.
Page 11.
Page 11.
Line 15. The executive director may provide guidance only to a person who is subject to the provision of this chapter, etc. I know it seems that's only one word, but we talked about it for a while.
And what was the outcome?
We decided to put the only in there. It was not there before. We inserted the only. And then we talked about whether it should be inserted by the advisory opinions, and we decided not to put it there. And then the other thing that we added that you were not here for, or that Ameren added, was the it's not a funding request, but it's an ability for them, an authorization for the commission to hire a part-time staff, an administrative person. There's no money needed because they have money in their budget left over that they're going to use. So it's not an appropriations issue, but it's an authorization that they should hire somebody part-time, half-time. So unless I'm forgetting something, I think those are the things we talked about when you weren't here.
You've captured it spot on.
And they are captured in the draft that's on our website now.
Right, which is draft 1.5, is that right?
Yes.
Yes, 1.5.
And Anthony, you did a great job. And we clarified that the position would be, we further clarified the part-time thing, right? That it
we said
would be half-time, so that we would be stuck with somebody considering part-time a quarter or a third.
Right.
So we put only in front of guidance, because guidance only goes to the person who is covered by it and requested. But the advisory opinion can go to others because it's a more generic guidance.
And it's public.
Yeah. Okay.
Yeah, if the director gets a sense that there's something going on, he's been hearing things being said by various people, or has an idea that maybe there's somebody's crossing the line, he can issue an advisory opinion based on what he feels people need to keep in mind, and that would be posted on the website and put out publicly. Whereas the guidance is only for that individual who says, is it okay if I go to Hawaii with Vince Aluzzi, that kind of thing. And the guidance would be, no, you can't go there with Vince Aluzzi.
Are we assuming here that Vince Aluzzi is paying, or that I'm just going along with him?
Well, that's depends on the circumstance. I was presuming he was going to pay.
Okay. All right. So is that committee, and Larry, does that meet your needs?
Yes, I think we're fine with it.
Okay. So
and the only other change that was made that I think is on your plate today is the language having to do with the financial disclosure reports to make it previous 12 months rather than calendar year.
Okay. So do we have that? Is that all in the new draft?
Yes, it is.
So can we get that off our plates?
Sure.
Somebody want to move that?
Brian's the mover.
Yeah, I was waiting because Allison had her hand up, but she's muted.
Oh.
I did. I was moving. While I was muted, I was moving that we amend H1. What number is it again? 135.
135.
With draft 1.5.
Okay. Senator Rahm, do you have your little stuff with you, or can you?
Gail can.
Okay.
Little stuff with you.
Are we ready to vote? Okay, Senator Clarkson.
Yes.
Senator Collmore.
Yes.
Senator Polina.
Yes.
Myself, Senator Rahm, yes. Senator White.
Yes.
And we have.
All right, and who would like to report that? Oh no, now we have to move
I would now move. I would now move that we pass out H135 favorably as amended.
Senator Clarkson.
Yes.
Senator Collmore.
Yes.
Senator Polina.
Yes.
Myself, Senator Rahm, yes. Senator White.
Yes. Would somebody like to report this?
I'd be willing to. I feel like I haven't been carrying my weight lately with the reports.
Well, that's because you've had a cold.
I still have a cold. I'm so congested. It's incredible.
It's sounding better than yesterday, though.
With the nice weather, it's sort of annoying.
Anthony, I'll make a suggestion for you.
Okay.
Vitamin C and echinacea. And
That sounds good. Yeah.
I don't want to use the word overdose in a bad way, but really, really take a lot of both. And I guarantee in about 2 days, the cold will be gone.
All right. I'll let you know if it works.
Okay.
I have another suggestion.
Yeah.
Traditional medicinal brand, Gypsy Cold Care Tea.
Cold care tea. Okay.
And then there's of course the old fashioned one. We're giving advice and counsel on YouTube. Classic.
That's true.
Bourbon and honey.
Or bourbon and honey. Right.
Yeah, that sounds like the number one. I'll try that first.
And a little lemon or honey. Ooh, all good.
And just so you know, not that I don't want to get more advice, but I'm just going to present this bill as mostly sort of technical changes and little tweaks to what we're talking about. There could be nothing controversial in this bill that I can see.
I think that's fair. I think that's
one thing I would like to get, Larry, from you, Larry, is just a reminder as to what your budget is and how much money you have left over, that kind of, because I can see, even though it's not an appropriation, I can see somebody asking, why do they have this money left over, that kind of a thing. So if you could just send me an email at some point.
Oh, okay.
That talks about, where the money, how much money you had and how much you have left, that kind of a thing, just so we can answer that question.
And he's likely to need it by Wednesday or Thursday.
Right.
What's the draft number?
1.5.
135.
Okay, that's what Gail wrote down. I've never seen a 1.5. So
it's 1.5.
Yep. Okay, let's start now. We had a little confusion. I admit that it was probably my fault. I'm taking a lot of fault today for things with the House, because I thought they were going to take up the whole ethics issue. And as it turned out, what they were taking up was H135, but not the Code of Ethics, even though they had it drafted. So we have H384 that was drafted for the House, but that's what we're going to walk through now. And if we are okay with it in the end, what we'll do is we'll make it into a committee bill if everybody agrees, or an S bill, okay? But we're going to use H384. And Amron, would you like to walk us through this? I know that we got the huge packet of information. I printed it out. It took almost a ream of paper from Larry with the report and the comments and all the comments that they received on everything. So we have that, but if we can walk through H384.
Yes. For the record, Amron Abergele, Legislative Counsel. I did also send to Gail, which I believe is posted a very high-level overview for this, just so that is up there as well, and sort of an easy reference of what this bill covers as you move forward with your review.
Good, thank you.
But I will start with the bill as introduced. This is H384, an act relating to adoption of a state code of ethics. Section 1 would amend the definitions in 3 VSA section 1201. This is in chapter 31 on governmental ethics. And you'll see there are a few additional definitions in here. Number 3, defining confidential information, which is information that is exempt from public inspection and copying under the public records law, or is otherwise designated by law as confidential. On page 4, you'll see there's a definition of conflict of interest, which you will see throughout the Code of Ethics itself referenced. You'll see that towards the bottom of page 2, this would delete or repeal the current definitions of gift in the chapter on governmental ethics and instead replace it with gift as that is defined in the lobbying regulation statutes in Title II, Section 261. On page 3, towards the bottom, you'll see a new definition concerning immediate family. You'll see this referenced in the Code of Ethics. On page 4, a new definition for person and a new definition for prohibited source, which you will also see in the Code of Ethics. In Section 2, this would repeal the current requirement that the Ethics Commission create and maintain a state code of ethics and places the code of ethics into Section 1202 of Title III. So subsection A, beginning on page 5, lays out the applicability of the code of ethics, which shall apply to all persons elected or appointed to serve as officers of the state, all persons elected or appointed to serve as members of the General Assembly, all state employees, all persons appointed to serve on state boards and commissions, and persons who in any other way are authorized to act or speak on behalf of the state. You'll see that within this code of ethics, all of these individuals are referred to as public servants. It's important to note that this code of ethics, while applying to all of those persons, does not prohibit branches of state government, agencies, or departments from adopting more stringent provisions regarding the ethical conduct of their employees. Subsection B lays out exclusions. The code of ethics does not apply to the functions of state legislators that are protected under the Vermont Constitution, those exercising judicial power under the Vermont Constitution, and members of the General Assembly, unless the code of ethics is adopted by rule by each house of the General Assembly. Subsection 3 lays out what is considered to be ethical conduct under this state code of ethics. Subdivision 1 is situations where there's a conflict of interest. Each time a public servant is confronted with a conflict of interest, the public servant shall either recuse from the matter or prepare a written statement that describes the matter requiring action, disclosing the nature of the potential conflict or actual conflict, explain why good cause, as set forth in subsection D, exists so that the public servant can take action in the matter fairly, objectively, and in the public interest, and include sufficient details that the matter may be understood by the public.
Can I ask a question about that?
Yeah.
On line 15 on page 5, none of this applies to the General Assembly unless the General Assembly actually adopts the code of ethics for its code of ethics also. Is that, and then because the reason I ask that is because the conflict of interest, our conflict of interest, the way we deal with it in the Senate is very different than this. We don't write anything up. We just stand up and say, under rule, whatever it is, I believe I want to disclose that I may have a conflict of interest, and then the Senate decides whether we have a conflict of interest or not, but we don't write anything up.
As this is currently written, this would not apply to members of the General Assembly unless the state code of ethics has been adopted by each chamber.
Okay.
But so I guess sorry, Madam Chair.
No.
Who does it apply to, and what kind of burden are we placing on that person? I'm trying to listen to the language and understand, is the local select board person, if anybody writes in and says they have a conflict of interest, is this just statewide constitutional officers? And
it doesn't apply to municipalities.
Okay, so it applies to statewide constitutional officers
and employees.
And
employees.
And also people who serve on a board of some sort, if you're on the state library board or something like that, it would apply to you as well, right?
Mm-hmm. Yes, this is at the state level.
And what is the burden on the person claiming a conflict of interest? What do? They just write in and say you have a conflict? Larry, explain.
If there's a conflict, then there are two options, either to recuse from the matter or to prepare a written statement. And the requirements of that statement are listed in subdivisions A at the bottom of page 5 through D on page 6. Those are the requirements for that statement.
But since it doesn't relate to the legislature, it would relate to somebody, let's say, who maybe is serving on the public service board, who might think they have a conflict with somebody who's bringing a matter before the public service board. Something I know it's not called the public service board anymore, but Utilities Commission.
It would apply to those commission members.
Or if I'm a state employee, if I work for the ag department and there's a farm that spilled a bunch of manure, and it turns out to be my uncle's farm, that kind of a thing.
Sorry, say that one again.
If I'm an employee at the Department of Agriculture, I'm just a regular employee at the Department of Agriculture, and I'm an inspector, and I'm not gonna be able to inspect a farm that's owned by my uncle.
That could be an instance that could be perceived as a conflict of interest.
Right.
Why don't I get a little bit further in this before we get too far into the details? Because I know there are going to be a lot of questions on this.
I have a tiny question though, because in line 15 says members of the General Assembly, but line 11 says state legislators. What's the difference in state legislators and the General Assembly? I thought it was the same thing.
It is.
Sorry, you're looking, could you repeat those line numbers, please?
Sure. On page 11, page 5, exclusions. And the line 11 says those, line 11 says the functions of state legislators that are protected. And then on line 15, it says members of the General Assembly. I'm not trying to be a pain. It's just, I thought they were the same thing.
That language could probably be more consistent. There was edits going on at different times between those two.
Okay, not a big deal. I just want to point that out.
And but also, it's just interesting about consistent references. I mean, we're referred to as each house. In other legislation, it's each chamber or each body. So it would be helpful to get us consistent all the way through. Whether are we a chamber, are we a house, or are we a body? And why should we be different from anybody else is always a puzzlement to me.
If I can suggest that we let Amron walk through this, and why we're different is because we set, if it's a core legislative function, it's regulated by the Constitution.
Right.
That's why we're different.
I know. I just think it's right.
She doesn't like being different.
I don't think legislators should be different.
We can have that conversation, but it's not relevant to this because it's not going to change.
I'm muting myself.
The Constitution says.
Got it. I know. It's just always sticks in the craw.
Okay. Amron, do you want to move on?
Yes. I will continue. I believe we were on page 6, subdivision 2, directing unethical conduct. A public servant shall not direct another person to act in a manner that would be unethical for the public servant or the other person to act. A public servant who has a conflict of interest shall not direct others to act in the public servant to the public servant's benefit where such action would be a violation of the code of ethics for the public servant. Subdivision 3, conduct after recusal. Once recused, a public servant shall not in any way participate in or act to influence a decision regarding the matter. Subdivision 4, appearance of unethical conduct. A public servant shall avoid any actions creating the appearance that the public servant is violating the law or the code of ethics. Whether the particular circumstances create an appearance that the law or the code of ethics have been violated shall be determined from the perspective of a reasonable person with knowledge of the relevant facts. Moving on to page 7, subdivision 5, preferential treatment. A public servant in the course of conducting state business shall act impartially, showing no favor toward or prejudice against any person. A public servant shall not give or represent an ability to give preference or special treatment to any person because of the person's wealth, position, or status, or because of any personal relationship with the public servant. When permitted by law and written policy or rule, a public servant may give preference to designated persons. Subdivision 6, misuse of position. A public servant shall not use his or her official position for personal or financial gain. Subdivision 7, misuse of information. A public servant shall not use non-public government information or confidential information acquired during the course of state service for personal or financial gain or for the personal or financial gain of any other person. Subdivision 8, misuse of government resources. A public servant shall not make use of state materials, funds, property, personnel, facilities, etc., for any purpose other than for official state business, unless the use is expressly permitted or required by law or by agency, department, institutional, written policy, or rule. A public servant shall not engage in or direct another person to engage in work other than the performance of official duties during work hours, except as permitted or required by law or by other policy or rule. Subdivision 9 concerns gifts. When gifts are prohibited, unless covered by an exception, a public servant shall not, and then there's a rather lengthy list of gifts, accept a gift under circumstances that could be inferred as accepting a gift that is intended to influence the public servant in the performance of their duties, use or permit the use of the public servant's government position or any authority associated with the public office to solicit or coerce the offering of a gift, accept gifts from the same or different sources on a basis so frequent that a reasonable person would be led to believe the public servant is using the public servant's office for personal gain, accept a gift in violation of an applicable law, rule, policy, or executive order, or directly or indirectly solicit a gift from a prohibited source or solicit a gift to be given because of the public servant's official position. There are exceptions noted in subdivision B. The first is gifts of $20 or less. A public servant may accept unsolicited gifts having an aggregate market value of $20 or less per source per occasion, provided that the aggregate market value of individual gifts from any one person does not exceed $50 in a calendar year. And then there are some exceptions to the exception. It does not apply to gifts of cash or of investment interests such as stock, bonds, or certificates of deposit, where the market value of a gift or the aggregate market value of gifts offered on any single occasion exceeds $20, the public servant shall not pay the excess value over $20 in order to accept that portion of the gift or those gifts worth $20. Where the aggregate value of tangible items offered on a single occasion exceeds $20, the public servant may decline any distinct and separate item in order to accept those items aggregating $20 or less. For personal gifts, a public servant may accept a gift given by an individual under circumstances that make it clear the gift is motivated by an outside relationship, family relationship, or personal friendship rather than the position of the public servant. Relevant factors would be history and nature of the relationship and whether the person, family member, or a friend personally pays for the gift. Event attendance. A public servant.
Yeah.
Does it make sense to differentiate between like the governor and other people? I mean, I just feel like the president faces a very different bar than someone on the National Parks Commission. You know, I don't know if there's been any contemplation of like difference when you have as much power as, say, the governor.
Around gifts?
Yeah. I mean, I'm just thinking about very extensive gift-giving policies for executives, you know, that doesn't apply to like a commissioner on a board the same way. Am I frozen?
Well, we can have that discussion
okay.
when we get to the discussing the bill itself. But right now we're just going through the bill.
So right now it applies to everyone equally who's
yes.
a public office, public servant.
Okay. Yes, to clarify, this is the same standard for everyone under this policy, regardless of sort of where they fall in the hierarchy of state government.
But not to legislators.
Unless this is adopted.
We are covered, the General Assembly. We are covered under a different policy for gifts.
And we couldn't choose to accept this as our standard.
We're not going to have that conversation now, please.
I know. Okay.
Shall I continue?
Yes, please.
Yes. She's getting fed up with us. Or me.
No, it's Friday afternoon and we want to have this conversation about these things and we want to have it with all of our colleagues in the Senate. But I think that we need to walk through the bill first to figure out what's in the bill.
And I just point out, it is such a beautiful afternoon. It's the first time I've opened my window since the fall. It's so exciting.
Yes. So the sooner we get through with this, the sooner we can get out there. Amron?
Right. Moving along to event attendance at the bottom of page 9. A public servant may accept a gift of attendance to a training or similar events approved by the public servant's supervisor and determined to be in the interest of the public servant's agency or department. And then a last exception, otherwise permitted by law, a public servant may accept a gift where expressly permitted to do so under state law. Moving on to page 10, unauthorized commitments. A public servant shall not make unauthorized commitments or promises of any kind purporting to bind state government. Subdivision 11, outside employment. A public servant shall not seek or engage in outside employment or activities that are inconsistent, incompatible, or in conflict with the public servant's official duties. Subdivision B, post-government employment. For executive officers, except as permitted in subdivision Romanet 4 of this subdivision B, an executive officer shall not for 1 year after leaving state service be an advocate for anyone other than the state for compensation before the department, division, agency, board, commission, body, or office in which the officer served at the time of termination of state service concerning any matter in which the state has a direct and substantial interest. Legislators, except as permitted in Romanet 4 of this subdivision, a former legislator shall not be an advocate for anyone other than the state for compensation before the General Assembly or any of its constituent parts until the end of the biennial session following the legislator's departure from the General Assembly. Romanet 3, legislative branch employees, except as permitted in subdivision Romanet 4 of this subdivision, a former legislative branch employee shall not, for 1 year after leaving state service, be an advocate for anyone other than the state for compensation before the General Assembly or any of its subparts, or the office in which the legislative branch employee served at the time of termination of state service concerning any matter in which the state has a direct and substantial interest. Romanet 4, which has been referenced several times above, is the contracting exception. The limitations in subdivision 1 through 3 of this subdivision do not apply to individuals providing information or services to the state pursuant to contracts of the state unless the public servant is otherwise prohibited from doing so by state or federal law. Romanet 5, representation restrictions. A public servant shall not, after termination of state service or employment, knowingly make with the intent to influence any communication or appearance before an entity of the state on behalf of any person other than the state in connection with any investigation, application, request for ruling or determination, rulemaking, contract, controversy, claim, charge, accusation, arrest, quasi-judicial, judicial, or other proceeding in which the state is a party or has a direct and substantial interest, in which this public servant participated personally and substantially as a public servant, and that involved a same party or parties as at the time of such participation. Subdivision 12, compliance with laws, rules, and policies. A public servant shall comply with applicable state and federal laws and regulations, including anti-discrimination and equal opportunity laws, and comply with applicable government codes of conduct. A public servant shall comply with any other applicable rules or policies established by executive order, agency rule, or policy. Subsection D, request for state ethics commission determination. A public servant or the public servant's supervisor may request that the state ethics commission review a statement prepared under subdivision C1, which is the subdivision when a public servant believes they may have a conflict of interest, may review a statement prepared to determine whether a conflict of interest exists, and if good cause exists, whether good cause exists such that the public servant can proceed in the matter without violating the code of ethics. That is to say, the person can submit this to the state ethics commission to get a determination in order to determine how best to proceed. In terms of the state ethics duty to respond, the ethics commission ethics commission responses to requests shall be in writing. As used in this section, good cause to proceed in the matter may include any of the following. The identified conflict or potential conflict is, I believe, actually that should say de minimis, but it says de minimum, de minimis in nature. The action to be taken is ministerial or clerical. the conflict is amorphous, intangible, or otherwise speculative, or the public servant cannot legally or practically delegate the matter. Subsection E, whistleblower protections for ethics complaints, consistent with 3 VSA section or 971. A public servant shall be free to disclose waste, fraud, abuse of authority, violations of law, or violations of this and other applicable codes regarding ethical conduct to the State Ethics Commission without fear of reprisal, intimidation, or retaliation. Subsection F concerns mandatory ethics education and training. Within the first 120 days of public service, a public servant shall engage in ethics training, which may be in person or online. Completion shall be documented by the department where the public servant is employed. A public servant shall participate in continuing ethics education at least once every 3 years thereafter. Approving continuing ethics education providers are the State Ethics Commission. Approved continuing ethics education providers are the State Ethics Commission, the Department of Human Resources, the Center for Achievement in Public Service, the Vermont House of Representatives Ethics Panel for House members, and the Vermont Senate Ethics Panel for Senate members, and any education providers approved by the State Ethics Commission. Copies of ethics training materials shall be provided to the Ethics Commission. On request, the State Ethics Commission may collaborate or assist ethics education providers. Section 3 repeals 2 sections of, a section in Title 3, 267, which is the post-employment restrictions, and then also a section in Title 2, Section 266B, which would repeal a legislator or an executive officer for 1 year after leaving office shall not be a lobbyist in this state. And Section 4, effective date, this act shall take effect on July 1st, 2021.
Bravo.
Thank you.
It was a lot.
Thank you.
You're welcome.
So now I suggest that what we do is, and I know we all want to get out of here, but I also know that we do have some limited time. And so I would ask the committee, can we spend another until 4 on this?
Yeah, I definitely have a constituent meeting at 4, but yeah, absolutely, right up.
But if we could do this till 4, we can get a long way into it, I believe. And okay, is that okay with everybody?
Sure.
No, yeah. Brian just fell off his chair, but that's okay.
No, his thumb is up. He's right with us.
Okay. So now let's, maybe what we should do is start going through it and have Larry, we can ask him the questions that we were actually asking Amarin, because she didn't make the decisions, she drafted it. So we can start going through it and asking Larry those kinds of questions. Is that okay, Larry, with you?
That's fine. I had a couple of introductory remarks if I can.
Okay.
You want me to do it now?
Yeah.
Okay, so Larry Novins from the Ethics Commission. I'm also here with TJ Jones, who has been consulting with us. He's with the Connecticut Ethics Commission, and then after that with the California, their equivalent in California. He's now a college professor and still consulting with us. The draft that you have is very, very similar to what we submitted to the legislature. There were a couple of major changes. The part excluding the legislature from this until and unless it's adopted by rule was not our idea. That was put in at the very last minute. So that is not our recommendation or our proposal. There may be a justification for it that I'm unaware of, and I just don't know what it is. And if there is, then maybe it makes sense, but I don't know that. The other thing, and I didn't notice this until just now, is the definition of gift in what you have before you is very different from what we submitted in our proposal. And I think I sent you all a copy of what we sent you back in November. And our proposal that we sent to you in November is a slightly different format because things had to be changed to fit the statute, but pretty much everything tracks very well with those two major exceptions. But the definition of gift is substantially different. And we referred in our proposal to several statutes and other places in our current laws that talk about things being gifts. And so that instead of just saying that it's as defined in Section 261 of Title II, we have an overriding definition. I can send that to you separately if you want, if you don't want to get into the weeds on it today. And we have examples of what is included within the definition of gift and what is not included. But basically it says anything that one gets for less than adequate consideration is considered to be a gift. And then there are certain exceptions after that. Things that aren't considered gifts would be if you inherit something, things like that. I don't know if I have the ability to share my screen. If I do, I could show you what we had, or I could just refer you to what we had earlier, or I can send it to you separately so you can see what the differences are. But that's a major difference. The other couple other things that came out during Amarin's presentation that you had questions about was what happens when there's a conflict of interest and whose burden is it to recuse. And what we had contemplated was if you see a conflict, you announce it, you recuse, you're done. There's nothing else you need to do. If you have a conflict and you decide that it's appropriate to go forward and continue, whether it's me or you or anybody else in state government, then you fill out a short form, say, I have what looks like a conflict in this particular issue. And I think there's good cause for me to go ahead and do it anyway. And what we proposed is that if you have a conflict and if you then proceed after finding that there is a conflict, then you fill out one of these forms and it's available. We're not saying you need to send it to the Ethics Commission or that we approve it or disapprove it, but it's available to the public. So people can see why is it that this person proceeded in this matter when they had a conflict, and the exceptions and the times when you wouldn't are set forth in that section D. So that's a major difference. So the bottom line rule is, and the preference would be anybody has a conflict, you recuse. And if you don't recuse, then maybe you write a short statement. And what we were thinking of is it doesn't have to be more than a paragraph. And your agency or your office or whoever keeps that. So if anybody from the public had a question about it, they could ask sometime in the future. We didn't want everybody to feel they were under an obligation every time there was a conflict to have to fill out a form and send it to the Ethics Commission. That's, I think, silly and overburdensome. So if people see a conflict and they recuse and move on, that's it. Life goes on and they recuse. So those are the major differences that I wanted to highlight, and that major question that you had earlier that I wanted to answer today. On the rest of it, I'll just wait for your questions. The version we sent you in the fall is annotated in the sense that you can see, looking at it, where we got the ideas that we used. A lot of them come from current Vermont statutes. Some come from statutes of other states. Some come from federal regulations, the Code of Federal Regulations. So when you look at it, you can see we just didn't make this up out of whole cloth and say, this is our great idea. There is a basis for everything that is here. So our hope would be that if you have questions, like where did this come from, that we'll be able to answer them. But it is available to you if you want to look at them whenever. I know you've got way too much on your plate to be able to do that kind of background work. So if there are particular questions, please address them to us. We'll be happy to respond to them and answer them.
So committee, what I would
where those are. Can I just clarify where those you said November documents, but on our webpage, Larry, I have drafts, amendments, and legal documents. Is that under that early legal?
It was the November 12th report that was sent to us.
November 11th, and then I repeated it. I sent it to you in an email in preparation for last Friday's hearing.
Right, thank you.
So it was sent about a week and a half ago now.
Right, yeah.
And I think I addressed it to each of you individually.
You did.
Yeah, and to Gail. So
let's, since we were talking about conflict of interest, since that was kind of the last thing that you brought up here, and there's a difference here with what you proposed and what's proposed in here. Committee, can we have a discussion about conflict of interest at this point and just try and figure out what the differences are and how we would resolve that?
Yeah.
All right, because I do have, first of all, I think that Senator Rahm had a question about how the impact it would have on somebody who has to do this, and knowing that it's less burdensome than what is in here. Your suggestion was less burdensome. I still am not so sure that somebody who is on the state library board, if they're in a board meeting and their wife is an author and the board is trying to decide whether they should buy this book or not for the library system, the person says, I may have a conflict of interest, but really, should they have to recuse themselves, or do they let the rest of the board members say that really isn't a conflict because it doesn't impact you? Or would they have to write somebody on I can see if it's a state officer or even an employee, but if it's a volunteer board member, can't they just disclose the potential conflict and let the other board members decide?
Could I respond?
Yeah.
Yeah, I think in that situation, if you look at the definition of conflict, and what's in the statute is essentially what we sent over. So there's no change in that language. If that person and an immediate family member, so they're going to make a decision that is going to financially profit an immediate family member, that to me sounds like a conflict of interest. And that should trigger a recusal. What we have in what we've suggested in the code is if somebody feels that they want the Ethics Commission to weigh in on this, then they can ask us and we'd be happy to weigh in on it. I mean, I don't like deciding these things without some kind of context, but on its face, that would look to me like a conflict of interest. And I think if it was, say, a voluntary board, the idea of having an ethics code is not to leave it to each board to make up their own rules about what is and is not appropriate. I think I could defer maybe a little bit to TJ to talk about how this works in other contexts. But my gut sense is that would be a conflict and the person should recuse. And if there people who work with them say, oh, that's not a problem, to me, not a good response.
I guess I should have clarified that a little bit. They're buying one copy of a book for $29.95 for the state library. There isn't the person, the author is actually going to get about 42 cents royalty on that book. It isn't a big financial boon to the family. And I guess maybe they would just write a paragraph and stick it in their files that says, we're not really standing to benefit from this humongous sale of one book. Senator
right, or maybe it's de minimis.
Right, that's what I was going to say. If they're going through a list of books to buy, and they come to the book that's written by your spouse, you could simply say, I'm abstaining from voting on this particular book. I'm recusing myself in this particular book. And that would be the end of the story, right?
Yeah.
Unless you vote then on all of them. It's like voting on the budget in the legislature.
Right.
We all have a conflict on something. But if we all recused ourselves from voting on the whole budget, there wouldn't be anybody left to vote on the budget.
Well, and this is a conflict we see in everything in this small state. I mean, this is a perennial conflict challenge we face, which is many of us wear many hats. There aren't enough of us to serve on, we're always going to bump into something where we have an involvement. It may not be a conflict of interest, but we may have some interest. It may not be a conflict.
I don't know if you want to hear from TJ on this or not.
Sure.
Thank you. I had the pleasure of meeting several of you a couple of years ago when I visited Montpelier to talk to you. So thank you for having me back. It's been a privilege to help Vermont navigate through this. It seems like there's really two things at issue. There's whether the conflict exists, first of all, and second of all, whether you can, irrespective of the conflict, go ahead and take action on it. And typically the way that conflicts are viewed are that they either exist or they don't. It's kind of like being pregnant. You're not kind of pregnant. You either have a conflict or you don't. Now, the situations where you can, irrespective of the conflict, go ahead and act usually fall into three categories. The first is de minimis situations, like 42 cents.
Right.
May be of such a small nature, the state might want to carve out a de minimis exception for something, under $30 of value. The second situation is one of impossibility. And those are more rare, but they typically arise under the statute where a single person has the authority to do something. That the statute says this individual is entitled to take this and responsible for taking this action. And the action has to be taken. But if it's not taken by that individual, it can't happen. And again, in those situations, the conflict exists, but the disclosure practices are, listen, I know I have a conflict here, but I have to take action. And these are the steps that I'm going to take to make sure that I don't benefit from the conflict. The third area is one in which, like the budget situation, where everybody benefits the same. If you're a tax commissioner and you have to do an interpretation on how, what the value of a car tax is, well, you own a car, you're going to benefit from whatever interpretation you do. But everybody in the world is benefiting, or everybody in Vermont is benefiting from the same thing. So if you separate the idea of the conflict, and define what a conflict is, then that's going to stick no matter who's operating in what agency on what issue. But then focus again on, are there situations where, irrespective of the conflict, we want this person to go ahead and be able to act? And for that, it becomes a lot simpler because those are the situations where you write out the statement that says, listen, I have this conflict. I wrote this book. It goes, using your example, the retail value is $29.95. I get 40 cents commission. I think it's a good book. I've disclosed everything to you. I think that I'm able to vote on this because it's of a de minimis nature. Then it's all disclosed. It's a matter of public record. And, for bonus points, you make sure that you've contacted the executive director of the State Ethics Commission and kind of cleared it through him. It really benefits to get sort of brief written advice in advance from somebody that you can say, I talked to the State Ethics Commission and they think this is probably de minimis, and then the choice is kind of yours and the agencies at that point as to how to go forward.
Yeah, that makes sense. Anybody else have? So what you're suggesting, Larry, is that people would, if they felt they had a conflict of interest that was greater than the rest of the population, that they just write an explanation and that be kept by the agency or if they choose not to recuse themselves.
Correct.
They write that explanation. If it seems major, then they can ask for an interpretation by the Ethics Commission.
If they wish.
Yeah.
They wish. They're not obligated to it. Or say it was some mid-level person in an agency said, I have a conflict on this, and their boss says, I don't think so. Either could ask us for our opinion on whether it's a conflict and whether or not they can proceed.
Well, I think that I actually don't see a conflict with the way this is written with what you're saying, because this says that they would write that paragraph. They would just write this little short thing containing these 4 elements. And it doesn't say what would happen with that, but they could then request. It doesn't say they have to send it to the Ethics Commission for advice. They could, which is exactly what you're saying. Yeah. So I'm not sure.
I have no problem with that provision. That provision mirrored what we sent over, and that's fine.
But I don't see a conflict with the. I thought you said that you disagreed with this preparing this written statement.
No, not at all. That was our idea. We're 100% behind it. What I took issue with was I wanted to raise the issue, is the exclusion of the legislature, Senate members and House members from coverage of the Ethics Commission that we did not ask for.
No, I got that, but you raised 4 issues, and one was the conflict of interest, one was the General Assembly exclusion, and one was the gifts.
Yeah, there were 3, I thought.
Yeah. And if I said I had a problem with the conflict of interest problem, then I misspoke, because I don't remember saying that, and I certainly didn't intend that.
Okay.
I think our definition, what's in there, is fine.
Okay, good, because I completely misunderstood that. I thought that when you pointed that out that you were.
No, right. I was just trying to respond to the question that came up in your discussion. That's all. But,
okay, got it.
Yeah.
So let's go back to the issue of the General Assembly not being covered. If we go to page 5, lines 11 and 12, it's very clear. It doesn't apply to that.
Correct.
Right?
Yes.
Because that's what's considered our core function, and we regulate ourselves.
And you're absolutely protected by the Constitution from anyone else questioning what happens in that capacity.
Right. And then you didn't put in lines 15 and 16, but the requester of the draft must have.
I believe that's the case, yes.
So committee, it very clearly said someplace that we are subject to the ethics violations under and I can't remember the term. I never can remember the term. Actions governed by law or something like that. And there's like 10 or 12 of them.
Yes. Yeah.
So that isn't anywhere in here.
Where's that, Jeanette?
It isn't anywhere in the Code of Ethics.
But where are those 12 points?
Oh, they're in different places in the law. One of them says you can't use your position for personal gain. One says you can't take a bribe. There's 10 or 12. What are they called, Brian? Actions governed by law?
Yeah, that phrase is in there, something governed by law.
And that phrase is in Title III, the Ethics Commission statutes, and they have those specific inclusions, bribery, things like that. Yeah.
Right. So remind me then the difference between the ethics laws and the Code of Ethics.
Well, the ethics laws as it currently exists talks about what laws apply to each of us.
Right.
And what the code does is it makes it greater and make clear that these other things are also would be covered by state law and applicable to everybody within the state, except for those excluded individuals or groups, specifically constitutionally excluded. So the fact that the statute says, thou shalt not take a bribe is in no way changed by the ethics code.
Okay. All right. So that is part of the law.
Yeah. And what the code makes very clear at the end is that everybody who's subject to the code is also subject to any other applicable codes or laws. So, for example, if I were an agency head, I would be subject to the ethics code, but I would also be subject to the governor's executive order saying what is expected. And so if the Public Utilities Commission has specific and more general and specific requirements for them, they would apply to them. I mean, basically what this ethics code says is it creates sort of a baseline that applies to everyone. There may be more specific and more comprehensive prohibitions or considerations elsewhere in law or statute or rule or executive order. And if there are, then those things apply. So this is just a baseline.
So given that, I do have some issues around this covering legislators, and I'll point out a couple examples. When we're going to take a vote on something, and somebody stands up and says, our rules say that the way we do that is we stand up and say, I believe I have a conflict of interest here under rule, whatever it is. And the body then votes on whether it's enough of a conflict to ask the person to recuse themselves. Mm-hmm. We don't write, it is the rest of the body that decides. We don't write a statement saying why we thought that. The rest, and that's in our rules. So this wouldn't apply to us.
It depends whether, there are two ways to go about this. One is to say the code doesn't apply to you unless you adopt it as a rule. The other is to say the code applies to us and then to put an exemption in the code for conflicts of interest for members of the General Assembly. So you have a general rule that applies to the world and a specific rule, I'm misusing the word rule, a general provision that applies to everybody when it comes to a conflict. And then you could have a specific one that applies to legislators. And so in the case of a conflict of interest of a legislator, this will be our policy, this will be our procedure that we'll follow, and that would be in the statute.
That would make me more comfortable.
And so I have the same question about the gifts. It's $20, but under gifts are defined as a political contribution. You're not going to tell us that we can't take a political contribution of over $20.
No, but they are gifts that are permitted by law. So you're allowed gifts that are permitted by law. And that's just a weird thing in Title II, where they defined gifts or political contributions as gifts. It's an unfortunate use of language and words. I don't know what the better one would be. It would seem to me political contributions to a campaign or something like that should be called one thing. To me, a gift is something that comes to an individual.
Political contributions.
Well, if they come to you as a candidate, I'm not an expert. You know much more about this than I do. But if you have a campaign committee and the money comes to your campaign, that's one thing. But if I put $100 in your pocket, that's a little bit different. That should go to the campaign. And, I'm trying not to let this balloon and escalate out of control because of the possible breadth of these things. But as I think we've defined it, and is a gift would be something permitted by law, And if a political contribution is permitted by law, then it would be okay.
Keisha, did you have a?
Well, I mean, I might have to look more closely at the language when I'm not balancing my computer on my deck and trying to enjoy the sunshine. But I think a lot of boards and commissions would want a little bit of flexibility to write this slightly differently for themselves. I mean, I'm just thinking about, for example, Jeanette and I, the chair and I both served on the UVM Board of Trustees. And, you know, at the end of our service, they give you a chair. Everybody knows I have a chair from UVM that I got as I left the board. Does that count? I mean, I'm still not clear, you know, if every board you could say, here's a gift for the end of your service, here's, you know, an acceptable gift because we wrote it down in our code. Like, I just want to make sure every board or commission has the ability to say, hey, we too would like to vote as a group on a conflict rather than have that person just write a letter and have it. So that's not particularly satisfactory to some entities. So how much can they depart from this code to sort of meet their own flexible needs?
I think there's room that if I guess the board of UVM wouldn't be covered because they're not part of state government. But if you were on
we're elected by the legislature, though. So.
No, we're on the board. It has
okay.
nothing. We don't represent the we don't represent the legislature. We're on the board of trustees. We represent the public of Vermont.
Right, but you're a legislator receiving a gift.
No, you're receiving the gift as a trustee of UVM, not as a legislator. The fact that you were
hat every time you accept a gift.
What?
Do you have to wear a different hat every time you accept a gift?
No, what I'm saying is that you are not, when you're on the UVM Board of Trustees, you are not there as a legislator. You're there as a public trustee elected by the legislature. You may or may not be a legislator. So you're not in that role as a legislator.
But are you not considered a public official in that role?
No, because this is state employees only. UVM is not, they're not a state entity. They're an instrumentality. They're not a state entity.
Well, the State Agricultural Board, though, is a public board.
I think that the entire UVM board is considered an instrumentality. They're not.
We're getting some.
Yeah, but this is what I'm saying. I feel like there's a lot of unique situations, and I'd want a board or anybody to say, oh, good, the state has like a draft code of ethics, like a template for a code of ethics, and we're going to modify it in some way to meet our needs and sort of publicly agree upon how we want to use this code and where we want to depart. Is that common in other places? Or
we can check in with the director of the code of ethics and make sure that whatever we're doing is okay.
Okay, here, let me step back a little bit here. I do not believe that UVM is covered under this at all.
Okay, fine. Then that's great.
Okay, they're not covered at all. The state colleges boards would not be covered. VSAC would not be covered. These are elected or appointed to serve as officers of the state or of the General Assembly.
Does the judiciary have its own?
Judiciary does have its own, and there is some suggestion that judiciary might be, they are exempt from this, yes.
Which is also odd.
Well,
can I respond to that? Because that's a great question. I've given this a lot of thought. There's a constitutional separation of powers that's recognized in Vermont, and nobody except the judiciary is in a position or can second guess anything they do as they do their jobs in a judicial capacity. When we submitted this draft code to you, we included a memorandum about why the ethics code should apply to non-judicial members employed by the judicial branch, for say a court clerk or an HR person in the Judiciary Department. A moderately long memo about that. There are, I believe, some 40 or some odd statutes that talk about where the legislature has told the judiciary what to do. And this is separate and apart from defining what are crimes and not crimes. But I would think that if you had a member of the judicial branch, say a clerk in the Chittenden court, who was giving preferential treatment to his friends or something like that, it would be properly part of the ethics code and not left to the judiciary to be the sole judge of the propriety of that conduct. That we're getting a little bit ahead when we start talking about enforcement. Who should enforce it? That's a separate thing. But in terms of who's in the best position to define the conduct that is acceptable, I think a general code that applies to everybody except those specific instances, you when you're legislating, judges when they're judging, but everybody else should be covered.
Right.
I'm not sure if Chapter 2, Section 4 of the Vermont Constitution might cover that, because, and Amarin, you can help me here, because it says, shall be vested in a unified judicial system which shall be composed of a Supreme Court, a Superior Court, and other subordinate courts. So it clearly says it's the court. And that implies to me the people who are acting in a judicial manner. But we should, so that number 2 there exempts the judiciary, the people who are judges. I don't know that it exempts the entire judiciary branch. That's something.
Yeah, that doesn't sound like it exempts the employees, the clerks.
That's we would have to, I think, ask judiciary how they interpret the Section 4 of Chapter 2.
Right. They commented. We do have comments from them.
Right.
They submitted. It was interesting. That was maybe been the first or second comment we received was from the judiciary. My memo that I sent you, and I can send it. Well, I think it's in the packet I sent you last week.
Yeah.
The 98 pages from November.
Well, I don't think I sent you the whole thing. But,
you did actually.
Okay, then maybe I did. But in state government, there are accountants, IT people, planners, clerical staff who interact with the public and with their coworkers. There are people who buy, furniture, supplies, computer programmers. They maintain the buildings, they furnish their facilities, they do studies to determine policy decisions. And that kind of work occurs in all 3 branches of government. It occurs in the judiciary, it occurs in the legislature, it occurs in the executive branch. And when you have employees who have broad discretion, they're subject to the same temptations, the same distractions, the same influences as anybody else in government. And so a statewide code of ethics should be in a position to guide them all. And having a consistent, independent source of ethics advice when somebody wants it would benefit us all. The judicial power and the exclusion in the earliest part of this draft legislation, or draft code of ethics, there are 2 constitutional limitations. That is, judicial departments shall be separate and distinct so that neither exercise the powers properly belonging to the others. So what is the power properly belonging to the judiciary? It's deciding cases. And so the judicial power is basically the right to determine actual controversies between litigants, and the power to decide and pronounce a judgment that will carry into effect for the people who are parties to the case that it's deciding. But But as some Vermont Supreme Court decisions have said in the past, those powers are not hermetically sealed off from the other branches. There was one case that I cited. Let's see. The constitutional provision that the legislative, executive, and judiciary department shall be separate and distinct, so that neither exercise the powers properly belonging to the others, does not mean an absolute separation of functions, since of necessity there must be a certain amount of overlapping or blending of the powers. So the question would be, what are the limits of judicial power? And, the big question here is, can the legislature apply a code of ethics to state employees of the judicial branch, not judges? And would having a non-judicial employee, public servant, follow the same code as everybody else, intrude on that separation of powers? And my belief is it doesn't. And the Supreme Court has also said that, and this is a case State versus Hunter versus State, 2004. The focus of separation of powers inquiry is not whether one branch of government is exercising certain powers that may in some way pertain to another branch, but whether the power exercised so encroaches upon another branch's power as to usurp from that branch its constitutionally defined function. So if you were to say, we have an ethics code that should be applying to state employees of the judicial branch, are you encroaching on their constitutionally defined power, which is deciding cases? I would submit that no, you're not. So the core power of the judiciary is determining controversies. And it's interesting, there are 5 places in the Vermont Constitution that obligate the Supreme Court to adopt rules. And in 4 of those 5, the rulemaking involves the legislature. So they're not separate and sacrosanct. They don't have carte blanche to do whatever they want to do. And so I would commend or recommend, I guess, that you take a look at my memo, because I think it says it much more than I can off the top of my head. But there are lots of statutes that tell the legislature what it should do. Let me think here.
Well, and we get involved with the judicial employees all the time, and when we've just gotten involved with them with their arbitration and with unionizing and we weigh in all the time with them.
Sure.
This seems part and parcel of what we already are doing fairly regularly.
Right. The judicial branch clerks and staff are subject to collective bargaining, as you said, and they're entitled to all fringe benefits and compensation accorded classified state employees who are similarly situated. And that's from the Vermont Employees Labor Relations Act. And then it was interesting, it was the legislature in Title III of that act that defined what judicial employees' rights and duties and prohibited acts are. So I would submit, if you can determine what are prohibited acts for them, you can certainly say this is the code of ethics to which we should all adhere. And that does not intrude on a core function of the judiciary.
Right.
Some of the powers granted by the Constitution are shared. Some are not. Only the Supreme Court can grant licenses to attorneys or discipline attorneys. That's theirs. It's unique to them. Disciplinary authority over state employees who are attorneys is shared. So, for example, when I was an attorney working for the Office of Professional Regulation, or working before that as a public defender, if I did something that my employers didn't like, I would be subject to employment or into any kind of sanction that they felt was appropriate. The fact that I'm a lawyer doesn't enter the picture. And so it's just like you have rules over your members, including attorneys, but it doesn't mean that the Supreme Court can't share authority over attorneys who are in the legislature. So as an attorney who works in state government, I have to apply by Department of Human Resources rules. And so there is all sorts of overlap here. And my point basically is that a code of ethics is, for state employees, it should be a practical reality for state government. There are other states whose codes of ethics do apply to judicial employees. In some cases, they even apply to elected judges because they're elected. So it makes it a little bit different than what we have here in Vermont. So the judicial branch has its own personnel policy, code of conduct, and employee discipline, so long as it is not inconsistent with law. So I would submit that there are plenty of bases for to conclude that a statutory code of ethics does not in any way conflict with judicial branch employee dictates. They may have their own code. It may be more specific and more stringent than the general code of ethics that applies to everyone else. And if that's the case, great, so be it. But I would feel that it would be good, a very good policy idea to say this applies to anybody who's going to buy furniture for their office, whether it's in the judicial branch or the legislative branch or the executive branch, shouldn't be dealing with their brother-in-law. And then when down the road, when we talk to enforcement, the question is, who's in the best position to enforce these things? Is it the judicial branch? It might very well be. Would it be someone outside the judicial branch? It might very well be. We don't need to decide that right now. But the standards that members of the public should expect of us all should be the same for everybody unless they are specifically excluded.
Aisha, did you have a question?
Well, I kind of wanted to move on from judiciary.
Yeah.
Sorry.
And okay. I sadly have to leave in about 4 minutes.
Right.
Yeah.
I apologize.
We all are.
Told that. I mean, I need hypotheticals in this situation, like, even though I know those can be problematic, but so, and I don't know that Tom helped me. Sorry, Tom, but you were kind of like, you either have a conflict or you don't. Well, so, okay. Let's say we were voting on pensions in the legislature and changes to pensions, and 5 senators out of 30, have a spouse or personally benefit from a pension as a we just have listed that at the beginning of session. So that's sufficient. I don't know how the Senate currently handles that. I don't think, do people get up and say, I'm not taking this vote?
The way it's currently handled is that, first of all, those senators would not have any more interest in the outcome of that than everybody else in the pension system. So it doesn't even apply to them. There is no conflict of interest. The same. That's very clear in our rules and in this definition and in Mason's. Right. But you mean
anyone who is vested in that pension system. Yeah. So they are not getting a personal favor.
Right. Okay. They're getting the same benefit that everybody else in that system is getting.
Right.
If the one that I remember distinctly always is that Jim Condos would always stand up whenever there was anything that dealt with public utilities, because he worked for Burlington Gas or Burlington Electric or one of those. And he would stand up and say, under rule such and such, I have to disclose that I may have a conflict here. And then the decision was, does the chamber feel he has a conflict? And there would be a vote, no. And then he would sit down and he would proceed to vote on the issue. And if we vote in Vermont, as you pointed out, it is very small. Claire and I once took everybody who had a conflict in the budget that select board nonprofit people, school boards, everybody, and we took all the legislators, and there ended up being about 5 people left who could vote on the budget because they all had some kind of a conflict. So it's pretty relative, and some of those had more significant conflicts than others, but as long as they're disclosed and then the body votes on whether or not they feel it's a conflict. That's the way it's always happened in the Senate, and that's the way our rules say.
Right. Well, what's helpful about that is that the public knows that as well, right? Because there's a perception issue, and I would hate for somebody who has a particular interest in a topic to say those 3 senators, are conflicted and sort of force them to do something that other senators don't have to do all the time. Like, we may all know that we have these various conflicts, but someone who's trying to use a very specific conflict against us for political reason, they file this complaint or whatever, and then we're obligated to speak to that in some way, is what it sounds like.
No, I don't think that when we're voting on something or doing something, people, if somebody wants to file a complaint, first of all, that's our core responsibility. So it isn't even covered by the Code of Ethics. Voting is our core responsibility, and that is, we set our own rules around that according to the Constitution. So somebody couldn't file, they could file a complaint with the Ethics Commission that says, I think Senator White has a conflict of voting on this renter's registry because she has an apartment.
Yeah, but that would exclude half the Senate.
I know it, but I'm saying they could do it if they wanted to. But first of all, the Ethics Code would say it's not our responsibility. It's covered by the Constitution and their core duties. And secondly, it wouldn't be a conflict. And you're voting on it at that moment. So conflict of interest is very different for legislators, I think, except around those things like using your position to advance your personal financial gain, or giving contracts to your family member if you're the person that's giving the contracts,
right,
or that kind. But voting is our core responsibility. So anyway, I've flagged a couple places in here that I think we need to have more, a lot of places that I think we need to have more conversation. So
may I just say, Madam Chair, before I have to leave, it's exciting to actually be dealing not with the technical changes, but actually with the Code of Ethics.
Yeah.
So I have to say, to finally be dealing with the substance of a Code of Ethics is really great.
It is.
So,
and I think I have this on for next Thursday.
Great. TJ, thank you for making the long trip up from Connecticut. We appreciate it. Goodbye, everybody. Have a great weekend.
Bye. Thank you. So I think that's, Gail, we have this on for next Thursday, right?
We do. And okay. Larry has already confirmed that he's going to attend.
Okay. And so what we'll do then is start going through it and looking at the areas where we need to have more conversation. I think the judiciary, the General Assembly, the gifts, the conflict of interest, and the how we deal with those boards and commissions that might be small and just have volunteer people on them. And those are the ones that I highlighted. And we'll ask people if they want to come, like we'll ask Pat Gable and Judge Grierson if they want to come, and so they can talk about that. We might want to ask Secretary Bloomer at some point to weigh in on the General Assembly issue.
Beth Festigi.
Yep, Beth Festigi. Mm-hmm. Okay. Yep. Does that make sense, committee?
Yep.
But it is exciting to actually be talking about something other than the technical changes.
Yeah.
It's been a long time coming. Thanks to Anthony.
Thank you. Let me just invite, if anybody has any particular things that you'd like me to prepare extra for next week, just let me know.
Go ahead, Keisha.
Well, I just feel like there are different tiers of gift giving, etc. If you're a major statewide office holder versus like you're on the parking commission or something, you know. So I really feel like to hold people to the same ethical account as the governor feels like a big burden to ask volunteer public servants on various boards and commissions, especially as we're trying to diversify them, et cetera. It just feels like there should be a different burden. And I would love to see more research on what it looks like in other states.
Okay.
Is that something that Thomas could do?
What?
Is that something Thomas could do?
Well, we could also probably get from VCL.
If I could.
And NCSL.
Yeah.
Okay.
I think we have, in fact, I think maybe the Ethics Commission did a number of reports for us last year on different ethics standards in different states, but on this very specific one, I don't know that we did.
I'll double
check. But let's have the conversation and see what it means. I mean, if $20 to the governor is nothing, but $20 to somebody else may be a lot. I don't know. I don't know how to tier that.
Okay.
Okay. Thank you. Have a great weekend.
Thank you.